Hi guys, it's Kathy. I hope you're doing well. We made it to Thursday. Week is almost done. Oof. Oof. So where I work, it's dinner shows. Okay? So we have the great big dining room, and the buses come and the big groups come. A lot of groups that we have are elderly. Elderly. There's lots of walkers, oxygen. There's just lots of elderly that come to see the shows. So yesterday we have a pretty full show. And the show ends and everybody gets up and they go back to their buses. I guess a few go to their cars, but most of them buses. But before they leave, they have to tinkle. Have to. So the bathrooms get packed. Now we have a huge bathroom, real long with lots of stalls. But I mean, you know how bathrooms are. It's a wall full of stalls, and then the little hallway in front of it. And like this little old lady was trying to leave the bathroom yesterday. So, she gets out of her stall and she's trying to get out of the bathroom, go over to the sink, and there's just so many people standing around. And she tripped on someone's foot and fell, like face first. Sort of almost to the door, like she almost made it to the sinks. And she can't get up, like she's down. And I'm in the dining room, and I'm just cleaning the tables, cleaning everything off the tables, and I hear there's a lady stuck in the ladies' room on the floor. There's a lady stuck in the ladies' room on the floor. So I immediately go to the ladies' room, and I walk in the door and I see this 91-year-old woman. She told me later, 91-year-old woman, like on the ground. She's crying in pain, her hip, and someone had shoved a pillow under her head. And on the other side, not where her hip hurts, the other side, someone was holding her hand, like sort of backed off, holding her hand. But she's just sitting there on this cold floor, which is very clean. I know it's a bathroom floor, but she was fine because that was very clean. So I go over right away and get down beside her, and I sort of slide my knees under her hip and lean her on me, and got her stable right. Her hips were like this big. She was just this tiny little girl, and and then she was like, oh, she as long as she didn't move, she was fine. I am, not a doctor, but I knew it wasn't broken because of where she said it was hurting. She's like, it's hurting down through the groin when I move my leg. It's not like my outer hip is broken. So I'm stuck there for 30 minutes now. Everybody else, all the other servers are cleaning the dining room alone. And the next show is going to start soon, and I'm not trying to be vain, but if another server would leave while we were cleaning, we would sort of notice it. But if I leave while we're cleaning the dining room, it's very noticeable. It's everybody, the whole building falls behind. And the ambulance comes and they take her away. But now I'm wondering if I'm in trouble. I don't know. I'm wondering if I'm in trouble. Nothing that I would change nothing that I did yesterday, not a thing. 100 times out of 100 times. That's exactly what I'm going to do. If there's a 91-year-old woman in pain, I'm going to comfort her. I don't care what's going on. I don't care. But my manager came up to me afterwards, and it was a very short conversation. Kathy, do you have any medical experience? No. Okay then. Oh no. Oh no. Well, that was a good conversation I had with my manager. I could be being dramatic. I'm just wondering if I'm in trouble when I get to work today. I want to. I'm not going to promise her I'll never do that again, because I'm going to do it every single time. Every time I'm going to do it. So I guess it could be a liability to the place that I work. Because, we watch court cases every day. You know how the world is right now. If you touch someone that's hurt, you could get sued and lose everything. No. No one told me not. Comments. See, Kelly, that's the whole problem. Like, legally, if someone gets injured, you're not supposed to touch them. You have to stay away from them. Yeah, they did call 911. They did. So you're not supposed to touch someone because, you're not a doctor and you don't know. You have no idea if you could paralyze them for life, by moving them a little bit. There's a 91-year-old woman laying on a cold bathroom floor in a lot of pain. You're going to get sued. You could lose everything. I don't care if I get sued. Even if I had $1 million trillion, I don't care. Because there's a 91-year-old woman laying on the floor in a lot of pain. So yeah. I'm telling you right now, I'm going to every time I'm going to, because I saw her, her hip. She just needed someone to she fell. She hurt herself. She thought it broke her pacemaker. She was scared, and there was all these people around her and confused, and her hip hurt. So I stabilized that hip right away. I just did. I didn't think about it. I didn't even decide to do it. It took less than a second for me to stand at that doorway, see something, and go to her hip and just hold her together till the ambulance got there. I don't know. I just hate the world that we live in. I understand. I understand if someone's in a car accident, if you pull them away from a burning car, you can get sued for everything. You're right. You're right, Eileen. I don't know. I'm not just gonna there's no way in the world I could let her just lay there and cry in pain. I told her jokes. I held her hand. I told her how good she was doing, I asked her what medications, because she said, I think I broke my pacemaker. I'm like, do you have any medications you need to take? Because what if she needs a heart pill? If you need a heart pill, you got to take those suckers right away. One of those things you put under your tongue or whatever. Do you have any medications you need right now? We'll go get them. And then, I don't know. I just don't know. It's just the world we live in today sucks. You're not allowed to help anybody. Because now I feel like, oh shit, I'm in trouble. I just hate it. I hate everything. I don't. Again, I just don't think. Yeah, yes. And the ambulance came, or they're even on the phone with 911. They're like she hurt her hip, and they asked, did she hurt anything else? Is anything else hurt? And I hear them say out loud, they're asking if anything else is hurt, and everybody around her is like, no. I'm like, her pacemaker, guys. She thinking she broke her pacemaker, which I know she didn't break her pacemaker. I think they're pretty solid in there. I would think that a fall wouldn't break a pacemaker. Well, Bill would know. Bill, how's your pacemaker? If you fall, will you hurt it? Bill, I miss you truly. I do. Alright, so that was 11 minutes. Holy crap, I talk a lot. Jesus Lord. So the other day, for those of you who weren't here, the other day we started this probate case. What we decided to do was go to Judge Sala and go to her most popular video and watch that. Alright? So we get an inch in to this video and we said, stop. Oh, Belle. We stop. We have to see this whole thing. So we started from the beginning and then we went sideways a little bit. That's okay. Well, now we're back to the beginning. We started with this video, now we're ending with this video. This is the last video. Remember, there's no verdict. What I know is they appealed it and the appeal lost. But I don't know who appealed it. But I have some ideas, I think. So, let's press play. Let's finally get to court here on Court Vibes.
All right. Welcome, Mr. Polderman. We didn't do the calculation.
And
do it across the street. So when they look,
and I'm wrong. So this is a completely we started here, but this is a completely different matter than what we were at. So this is a different issue in this case. Okay? I don't know, Metal. I think she's very good looking. So, alright, so first we had she goes missing. Deanne goes missing, right? And then there was a murder trial without a body. And then we have the probate court here where he showed up in jail with someone else. And that case was the one that I guess we finished yesterday. I didn't know that, but we finished that yesterday. So obviously he got out of jail because the judge did not find her dead the first time. And I think that's what they appealed and lost. They didn't find her dead. And then, because you can tell they didn't find her dead because the appeal was the conservatorship of Deanne, or D-A-W. It was in the conservatorship of D-A-W. If she was found dead during that, it would have been the estate of D-A-W. But it was the conservatorship. So, He got out of jail then, but he had a contempt charge, 2 contempt charges. One was civil and one was criminal. And I think he was supposed to spend 16 days in jail. He only spent 8 days in jail, and then the jail let him out. And that's why they're here. The prosecution's mad that he didn't spend all 16 days in jail. I'm looking at it, Monica. So that's where we're at today. This right here is one of her most popular videos. I don't know why.
Looked at the file. Apparently what happened was they saw that he had done
behalf of the government, and provided that the date and the execution of the sentence was of no fault.
All right. Welcome, Mr. Polderman.
Sorry, I was trying to fix Twitch.
You'd like
I
to
didn't
put your
realize.
appearance on record?
It's good now.
Good afternoon, Your Honor. John Polderman on behalf of the successor conservator Charles Bullock.
Thank you. We're on record today, as you're aware, I'm sure, to review the error in the calculation of credit for time served as it relates to Mr. Dale Warner, since he was given credit for 8 days as a result of we didn't do the calculation in-house. They do it across the street. So when they looked at the file, apparently what happened was they saw that he had done 8 days on contempt and saw contempt again and gave him credit for 8 days on the civil contempt towards the criminal contempt, which was obviously not appropriate. So today's hearing is to review that issue and to hear the attorney's recommendations. I wanted to clarify it for the record as to what happened. And then secondly, to allow the attorneys to be heard on any arguments that you may have as far as what should be done to remedy that at this point. Secondly, Mr. Head has raised the question of the stay the automatic stay that's directed by the statute when there's an appeal for purposes of 21 days. I also have the motion for reconsideration. He's requested a stay past the 21 days. I had articulated that effectively I was going to make a ruling on the motion for reconsideration as well as the issue that was up for today. There is no automatic hearing on the motion for reconsideration. So I think that catches you up. Mr. Head, would you agree or disagree?
Yes, as long as we are acknowledging the fact that there is a statutory stay. Yes.
Yes, for 21, yes. You cite 600.867. I have read it. Yes.
Just clarification, I think Mr. Head has withdrawn his motion for reconsideration. That's what I heard.
I don't know if you, is that what you want to do?
Unless the court's going to set aside the judgment of contempt.
The motion for, I'm just going to cut, I'm not going to allow you to do that because I've already got an order on it. So I'll issue this today and you'll be able to take that with you. And if the Court of Appeals doesn't like it, I'm sure.
Monica, that stinks.
Okay. So if I understand, Your Honor, you want us to still make a record or at least preserve arguments related to this 8-day potential issue. Okay. Well, aside from the stay, there's a doctrine called credit for time erroneously at liberty. And that has
Credit for time erroneously at liberty. Monica and Kelly, thank you for the cheers. I know Twitch isn't working right now, but the cheers worked. Thank you.
has been recognized in several states, including the state of Michigan. In People versus Lewandowski, that's 237, Mishap 612. It is acknowledged and recognized in the footnote in that case. It's also been recognized by the 1st, 2nd, 3rd, 5th, 6th, 7th, 8th, and 9th and 10th circuits in federal court. The doctrine is essentially coming out of the common law, and it states that a convicted person is entitled to credit against his sentence for time that he was erroneously at liberty, provided there's a showing of simple or mere negligence on behalf of the government, and provided that the day in the execution of the sentence was of no fault of the prisoner. That's what happened here. Essentially, that's what happened in the Lewandowski case, which refers to other cases from other circuits, where a prisoner is erroneously let out of the jail or prison through no fault of his own. In other words, if he didn't escape. That's essentially the government is stopped from playing cat and mouse with him and putting him back in jail. And he receives credit for that time that he's erroneously at liberty, as long as it's through no fault of his own. So under that doctrine, this court, should it be so inclined, and I know Your Honor has not set forth what your opinion is or what your intentions are, but if this court was inclined to make the attempt to reincarcerate him for that reason, this court cannot do so under that doctrine. Aside from that doctrine, there's waiver and estoppel. There's several courts have held that, again, when a government is stopped from playing cat and mouse, this is a direct quote, the government is not permitted to play cat and mouse with a prisoner, delaying indefinitely expiration of his debt to society and his reintegration into the free community. And again, that's from People versus Lewandowski, which I already cited on the record. It also was citing Dunn versus Keohane, which is 14 F3D 335 out of the 7th Circuit Court of Appeals. The decision to release Dale here was not this court's, it was the jail's. Whether that was erroneous is immaterial for the purposes of our discussion here today. In addition to the waiver and estoppel theory and the time for erroneous at liberty theory, it's also a violation of Mr. Warner's constitutional rights, both under the United States Constitution and the Michigan Constitution, to reincarcerate him at this point that he's been let free after serving a portion of his sentence, after the court found that he was in contempt of court. More specifically, it would be a violation of Michigan Constitution, Article 1, Section 16, and the 8th Amendment of the United States Constitution, both of which prohibit cruel and unusual punishments. And under the Michigan Constitution, it's cruel or unusual punishments. The federal Constitution is and. The idea of reincarcerating Dale is
You're
foreign,
right,
quite
pro
frankly.
wrestler. It's
And
funny.
if not shocking to the conscience, I don't know what is. There's nothing more cruel or unusual than releasing an inmate, then waiting 2 weeks after he reintegrates with his minor child, and then saying he's got to go back because somebody at the jail messed up. So that would certainly be unusual. I'm sure nobody in this room has heard of that. And my 15 years of practice, I've never seen or heard of anything like that. So because of the fact that it's unusual, it's unconstitutional under the Michigan Constitution. And it's also cruel and unusual under the federal Constitution. There have been some courts that have opined on that issue. For example, O'Brien versus Saginaw County, 437 FSUP 582 out of the Eastern District of Michigan from 1977. The court said in determining whether the conditions of confinement of convicted persons constitute cruel and unusual punishment, the courts have increasingly viewed the effect of the incarceration on the individual. So the prison conditions should not threaten a person's sanity, physical or mental health. And certainly releasing somebody from jail and then requiring them to go back after a period of time would certainly affect their sanity. So for all of those reasons, in addition, Your Honor, once there's been a valid sentence, the court cannot amend a valid sentence once it has started to be served. The court simply just doesn't have that ability. And that is under a court rule. And that is, I believe, that is MCR 6.429. The court may not modify a valid sentence after it has been imposed, except as provided by law. And again, there's no law that permits the court to amend its sentence or to reincarcerate Mr. Warner after he's been released from jail. Additionally, the credit for time served is determined by the jail. I'm not sure of a specific statute or court rule that has a uniform rule. I know that different jails have different credits that are applied for good time. And that's an issue that was that's in play here. And finally, MCR 7.208 provides that once a claim of appeal has been filed, the trial court may not amend or set aside the judgment or order appealed from. So there cannot be any amendment to the sentence at this juncture. So aside from the fact that
They took the
these
witch?
proceedings are stayed,
No. Halloween's
the
over.
court does not have the ability to reincarcerate Mr. Warner at this juncture. And we would ask for a ruling on our motion for a stay pending the outcome of the claim of appeal that we filed. So that we can get that ruling and we can present it, and if it's denied, we can move the Court of Appeals for a stay pending appeal. Thank you.
Thank you. Mr. Polderman, would you like to be heard on this issue?
Yes, Your Honor. A number of things. One is the Court of Appeals
okay.
has jurisdiction upon.
Hey, Mr. Polderman, it's very difficult to understand you. You're breaking up a little bit. So I don't know if you could, hopefully you're safely pulled over and not actually moving at this moment. I think we'll have to ask you to. It's muffled. We'll come back to you in a few minutes then, once you've been able to find a safe place that you could maybe stop for a few minutes. Mr. McFarland?
I'll be at the courthouse in 5 minutes.
Your Honor, this is not an amendment of a sentence. This is actually carrying out a sentence that was given by this court. These sites that I've heard, I haven't heard any site that's a Michigan site. I could be wrong, but these seem to be federal sites, federal court. They could be used for persuasion, but we're not mandated to follow those. So by this reasoning, if you have somebody I'm not saying this is this case, but if you have somebody convicted of murder and they are released, I find it hard to believe that Court of Appeals or Michigan Supreme Court is going to say this person is out free, that their time has been served. It's cruel and unusual punishment. When given a life sentence, they don't expect anything. They should expect to be released sooner. Dale Warner likewise was given a some certain sentence, Your Honor. There is a certain amount, there is a certain time. He had counsel. It was quite clear. We don't have any transcripts to indicate to the contrary that the court was ambiguous. Matter of fact, it was very clear. Does Mr. Warner have a responsibility, or at least an ability to say, you know, I understand I was in court, I shouldn't be released as early? That's a question. None of these cases that were cited, although I don't have copies, they haven't been right with me, but I don't believe that any of these cases deal with the jail's policy on releasing early or not. I think it was just a miscalculation. This is not a new or an amendment. This is an existing order. I think the court had the ability to issue a bench warrant as soon as it discovered that. So this is not something new. We're not halting something. There's already an order. He spends the time in jail. Probably could be clarified by a bench warrant, but the court is allowing counsel to order. I do not believe it's stayed by the appellate process, Your Honor. And that's my position.
Ms. Berger. Yes, thank you, Your Honor. I am in agreement with Mr. McFarland on this point. I also do not believe that these proceedings are particularly stayed. I've reviewed the court rules and I can't find anything that exactly pinpoints to this type of ruling that's been made in the past in a probate proceeding. And in that regard, I defer to the court. In relation to the issue of the 8 days that were not served by Mr. Warner, I think that it's very relevant and very pertinent to know that, by my opinion, which will be evidenced by pleadings that will be filed in this court very soon, that Mr. Warner has continually been in violation of this court's order while he was erroneously released. I do not have those ready to be filed today. Otherwise, they would have been presented to you before today. However, there are several incidences where he is attempting to operate business through the farm, where he is directing others to violate the court orders through himself and at his direction. And I believe that, in addition, I believe that his absence from this court today is further evidence of, I suppose, his inability to follow the court's order. If Mr. Warner would have been released and we wouldn't have any of these issues, if literally new information about other vehicles that are owned by the estate or in part by the estate wasn't surfacing within the last week, I would probably have a different position. Is it unfortunate for Mr. Warner that he may have to go back and serve those 8 days? Sure, it might be. But it's also unfortunate that he literally cannot help himself from violating these court's orders over and over again. So I'm asking that he be remitted back to jail, that he be ordered to serve those other 8 days. That I would ask that there's a finding that this is not an amendment of a sentence, that it's just carrying out of a valid sentence. And maybe by not ordering him back, that would be an amendment of your sentence. And because there's an appeal filed, we can't do that. So I think your only option, Judge, is to remand him back to the jail. Thank you.
Yes, Your Honor. I also agree with Mr. McFarland. I agree with Ms. Berger as well. I also looked and tried to find case law and other law that would be on point here as far as the stay, you know, given the fact that the motion for reconsideration was filed, gives the court an opportunity to correct or change or do anything that it wants to do, and then an appeal gets filed later. So I was thinking that no would not be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your honor's judgment, and you'll know what to do. On whether or not Mr. Warner should go back for 8 days, on behalf of Angelina Warner, I have to say that no, he should not go back. She was delighted to have him home. She was surprised, as we all are, because she wasn't expecting him for another 8 days. But she just really, it'd be very hard on her, devastating, judging by her reaction to seeing him when she came home that day. It would just be extremely upsetting for her, for him to go back for 8 days. That said, I leave it to the court's discretion, for the court's judgment. Thank you.
I think Mr. Alderman, did you want to,
Yes, Your Honor. I'm actually in the courthouse parking lot. I was able to make it here, but I would agree with what Mr. McFarland has said as far as this not being an amendment of the court's order. It would be actually just carrying out what the court had already ordered. And on this issue with the Court of Appeals having jurisdiction, MCL 600.308 provides that the Court of Appeals has jurisdiction of all final orders. The fact that the motion for reconsideration is still pending means that there is not a final order of the court at this time. So I would submit to the court that there's actually not a stay on this proceeding today, and the court should enforce its order. The fact that someone was released early does not negate a valid order of the court. And I guess if the court is still concerned about that issue, I think we should have a chance to respond in writing to these cases that Mr. Head has cited. I don't know that any of them are directly on point or speak to criminal contempt, which is a violation of the court's order and affront to the dignity of the court. And the court has the ability to ensure that its orders are enforced and carried out. So in short, there is no stay. This court has the jurisdiction and authority to enforce its orders. There's nothing cruel and unusual about the Lenawee County Jail. That's not what's before the court today. And it's certainly not an amendment of this court's order. As Ms. Berger said, if in fact the time were shortened, that would be an amendment rather than enforcing it as written.
thank you, go ahead.
Thank you, Your Honor. With all due respect to Mr. Polderman, there is actually a court rule directly on point. That's MCR 7.208. That's the authority of court or tribunal appealed from. And that says limitations, subsection A. After a claim of appeal is filed or leave to appeal is granted, the trial court or tribunal may not set aside or amend the judgment or order appealed from, except by order of the Court of Appeals or by stipulation of the parties. So there's also criminal contempt is a crime, and therefore an order finding a party in criminal contempt of court and sanctioning the party is a final order from which a contender may appeal as of right. And that's in Ray Maroon 295 Mishap 312 from 2012. So this, but because there's been a claim of appeal filed from a final order, it's very clear that a judgment of contempt is a final order. And because we have moved to withdraw the motion for reconsideration, even if the motion for reconsideration were to somehow render a final order not a final order, which is not the case, but even if it did, we've moved the court to withdraw. But that's not what the court is going to do. I understand the court's going to issue a ruling anyhow denying it. regardless, that order is going to be entered one way or another. And the claim of appeal has been filed, and therefore this court no longer has jurisdiction to do anything with respect to that order, especially when that statutory is in place. The issue that this court may have with respect to Mr. Warner not serving what this court believes was his full sentence is between this court and the jail. It is not between this court and Mr. Warner at this juncture. He was out for not a full 9 days prior to the claim of appeal being filed. And after that, now he's been out for a full 15 days. So he should receive the credit for that he deserves under the doctrine of erroneous time and liberty, which is recognized by the state of Michigan and People v. Lewandowski, as I cited. And for all the reasons I've otherwise said. The other issue is with respect to what Ms. Wilhelm indicated. It would be detrimental, it would have collateral effects to the Warner family, especially young Angelina. And it's certainly not fair to her that the jail decided to, in this court's view, release Mr. Warner early. This court knows from collateral proceedings, from other proceedings, the detrimental impact that Mr. Warner's incarceration had on Angelina, as was previously expressed in the minor guardianship case from her counselors, from the guardian ad litem, from the Department of Health and Human Services. So if this court were so inclined to believe that it does have the authority to reincarcerate Mr. Warner, I hope that this court would take that into account and consider the overwhelming and overriding collateral consequences of such a ruling. But again, for all the reasons I've stated, I don't believe, with all due respect, that this court has that authority at this juncture. I would be remiss not to mention, while I was not here for the prior proceedings, Mr. Warner was jailed for violating a civil court order. He was not jailed for a violent offense. He was not jailed for assault or a domestic assault or a battery or some type of a violent crime, some type of a drug crime, some type of a crime with a victim. There was not that type of an issue here. And while I was not present for those prior proceedings, and forgive me, I know that I don't know the entire history, it's surprising to me, because I do practice in criminal defense, that Mr. Warner was jailed for such a length of time, when I have seen, even just today, numerous dozens of criminal defendants that are charged with violent crimes that are sentenced to less. Just the court using its equitable powers, I would hope, would factor that in if the court does believe that it does have the authority to reincarcerate Mr. Warner at this juncture as well. Thank you.
All right, as it relates to the request to stay, I appreciate you bringing to the attention of the court MCR 7.208 because it does clarify, I think, in part, some of the decisions that are being submitted to the court today. For example, subsection D indicating probate actions, that the probate court retains continuing jurisdiction to decide other matters pertaining to the proceeding from which an appeal was filed. There is no amendment to the opinion that the court previously ordered. This is properly considered certainly something that pertains to the proceedings from which the appeal was filed, but is not addressed in any way, shape, or form by the record. The court is also allowed to look at defects in the record under subsection C. There's also the fact that this motion for reconsideration really concerns the appeal. It has not been addressed, which would mean that we do have effectively an incomplete record for the Court of Appeals to review. And it does raise issues that will be addressed by the court in part. And those will be obviously very important for the Court of Appeals to consider. So for all those reasons, the court does have the authority to rule on the issues that have arisen today, including, of course, on the request for stay, which is denied. I do not think in this particular action, especially where we have the litany of examples of disregard for the court's authority by Mr. Warner up to this point, and apparently potentially continuing, that it's appropriate to allow the proceedings to stay. That creates an unreasonable barrier for those that have been appointed as conservator and attorneys to be able to properly adhere to their fiduciary and legal obligations to the estate and those that they represent. Further find that the ruling on the motion for reconsideration is appropriate to complete the record and to make a decision on the error that was made in calculation of the credit that was given to Mr. Warner. I'm not going to reincarcerate Mr. Warner. Part of the beauty, I believe, in living in the United States of America is that we do have the opportunity to look at issues of liberty, and when in doubt, we should look at them in the most civilized way as possible. In this particular situation, he certainly should have had that additional 8 days. He may, in fact, be subject to the court's proceedings again in the future, according to what I'm hearing today. So on one hand, I think it's appropriate to close the door on that issue to honor the liberties that we all adhere to and uphold in our country, frankly. That was cited in many jurisdictions on the federal circuit. And so I think there's plenty of authority there. And I also don't believe that it serves the interests of Angelina Warner. And I also don't believe that it was part of the intention of the court to put Mr. Warner through another arrest booking process that was not contemplated by the original order. So we will allow him to remain outside the confines of the Illinois County Jail until and unless there are issues that arise in the future. We'll close the door on that particular chapter. And finally, the court's order after the motion for reconsideration will also be issued today. And there will be an evidentiary hearing set on effectively what is the request for a Ginter hearing. So if I could ask you all to look at your schedules, I'd like to look at some dates and times for that.
Your Honor, I would ask for a finding of fault be placed on the jail. Specifically in your order, I'd like to preserve that for the record. I would also like to get that order in writing. I don't have a client. I've said that 100 times, she's not here. But I do know that if she were here, she would want the people responsible for letting Mr. Warner out of jail erroneously held accountable. And I don't know what will follow, but I'm asking for that written order today. Thank you.
Frankly, I don't want to say that it's simply the jail. All of us sitting here today in this room had the ability to calculate that appropriate release date and to make sure that that was communicated effectively to the jail. Asking our jail personnel to differentiate between civil contempt and criminal contempt under the same case file number was understandably out of the ordinary for them, frankly. So I think that as much as I would love to say that it is simply their fault, I think that we all sit responsible in some part for the miscalculation. And I just want to say that, frankly, I'm glad to see that the error is made on the side of liberty rather than on the side of incarceration. That's part of, again, the reason why we have the benefits of living in this country. So I appreciate your frustration and your request, Ms. Berger, but I'm gonna deny it for those reasons.
Thank you, Judge.
Anything else?
That's it.
Okay, all right, so on the, effectively, what we're referring to is the Ginther hearing.
All they talk about a timeline scheduling from the here on out, and they were all wrong. So we're not going to listen to it because they were continued and things like that. Here's what I know, and I was wrong in a couple places, but that's because it's just confusing. Okay. April 25th, she's last seen with him. That's when Deanne was last seen with him. And then she just vanishes. So from 21 to 22, huge media coverage, lots of searches. They're searching for her everywhere. MSP takes the case over from the sheriff's office. I don't know what MSP is. Michigan State Police. Yep. And they take it from them. Okay. In 2022 and early 2023, her children get this probate case going to declare her dead. She is declared dead. It just takes a long time with Judge Sala. So 2022 it starts. She was declared dead in 2024. All right. And then there's an appeal. And the appeal for the conservatorship is because of the child. The guardianship of the child is what they had issues with. That appeal was lost, but it did change some things about the guardianship. But you can't see what they are because it's all locked. He did have a contempt case, 2 of them, civil and criminal. The civil was for not complying with orders for Dee's estate, and he was jailed until he complied. And then the criminal is 93 days of jail over multiple criminal actions taken against the estate of Dee Warner and violating prior orders. And so he was released early, 8 days early from that by mistake. That's before the murder arrest. Okay? The murder charges are November of 2023. Now this is before she declared Dee dead. He charged him with murder and tampering with evidence. His bond was $20 million. And then he had a bond hearing which was dropped to $10 to $15 million. Alright. He's been in jail since 2023. Since they arrested him for murder awaiting trial. So they had the prelim, and then they had the trial set for September, but then, you know, how things go. Remember we saw that the attorneys starting to argue that he's never going to get a fair trial here. Everybody's already made up their mind. There was a venue hearing. Judge Sala denied it. So he is set for trial January 27th. I have it in my calendar. But there's also a civil wrongful death suit by the children. $100 million against Dale. I don't know how he would ever pay that. I don't understand. I don't understand that part at all. So we have to wait till the 27th to hear this trial, if we watch it. If we want to watch it. That's up to us. All right. Let's go here. for one little snippet.
We'll defer on that matter. Position number 41 has been handled. Position number 42, 2025 R0186, the state versus Corey James Wiles.
Yes, Amanda, I just emailed you something you're worried about. Your Honor, this time we're gonna not go to plea, waive formal arraignment on behalf of Mr. Wilds.
All right, let the record reflect that the public defender's office represents Mr. Wiles. He waives formal arraignment, enters a not guilty plea, and he'll have 10 days to file appropriate motion.
And Your Honor, if you will recall, I spoke to you about the modification of Mr. Wilds' bond condition yesterday in drug court.
Okay.
And we've got an order as soon as Ms.
State have any objection to the modification?
No, Your Honor, no objections.
Does it not come through yet? Okay. We can just get a signature on it whenever.
We'll modify the bond according to what was brought to the court's attention yesterday in Dodge County Drug Court.
Thank you, Your Honor.
All right, position
Do you got your-
43 has been handled.
Okay.
Are we good?
We're good.
Mr. Wiles, now just 10 minutes.
Very good. Position 44, 2025 R0189, State versus Benny Thomas Gary II. All right, he's also number 5 on the plea calendar. Speeding ticket. The state have an announcement as to Mr. Gary.
Your Honor, the state would ask for bench warrant.
I'm
Benny
so
Thomas
mad.
Gary the second come into court of your bond to be forfeited.
Guys, for the last week, 7 days, whatever, I have this whole system. I've been setting up this whole system. I'm working hours and hours, days after days after days on it. Today was supposed to be the first time I use it, put it into practice, and it didn't work. Oh man, I'm so mad. So what was supposed to happen right now is I was supposed to be showing you this revocation hearing. And I found this in a long, drawn out, weird way that was supposed to save me time for the rest of my life. I would save so much time. And unbelievably, it did not work. Because this is not clearly not a revocation hearing at all. So, I am going
eligible
to
to apply for limited privileges. My bailiff can provide you with the
Switch.
form as necessary.
this up and see if I can get a deer. We're gonna go with hunting. I can't believe this didn't work. I'm so mad. I spent days trying to get this right, and here we go. We're gonna do this one instead while I fix that other one. Judge Stannis Berry, Ohio, Licking, Ohio.
Defendant has any credit as a result of being incarcerated on this case at any time, he shall receive credit for that time towards the
I
10
don't
days
know
that he
if
has
this
to
is
serve.
right. Oh my God,
He'll be on
no.
probation for 1 year. He'll be required to abstain or abstain from alcohol, not consume any alcohol, no drugs, no abuse of prescription medication. If you're asked to submit to a drug or alcohol test by your probation officer or any law enforcement officer, you're required to submit. I'm going to order that you undergo both a drug and alcohol as well as a mental health assessment, because if there are issues on both fronts, we need to deal with those at the same time. You're to maintain suitable employment and follow any other rules the probation department sets. You're going to save a little bit of money on the fine on this because the effective date of the increase of the mandatory minimum fine was after you were cited. So your fine on this charge is $565. It'd be a 1-year license suspension from the date of your citation, and the defendant has served the mandatory hard time. As noted, the court is granting the state's motion to dismiss the A2 charge.
It's the next one. Just hang
In
tight.
25 TRC 6415, on the charge of OVI, court will impose a 180-day jail term, suspend 170 days of the jail term, and grant the defendant credit for any time he may have served while being held in the jail. He'll be on probation for a period of 1 year with identical terms and conditions. The fine on this charge, the mandatory minimum, is higher because the effective date was April 9th. Our charges filed after that were subject to the increased mandatory penalties. So the fine on this charge is $715. Court will suspend the defendant's license for 1 year, effective from the date of the ticket. That's July the 8th. On the driving under suspension charge, the court will impose a 3-day jail term, a $250 fine, 6-month license suspension effective today, and the court will provide that all jail terms imposed between the two cases will be served consecutively. And therefore, the defendant has a total of 23 days to serve, less any credit he may be entitled to for being held in lieu of bond. What was it that I was going to put in that I didn't think that I did? I saw something, I was like, oh yeah, oh, I think a report date. Nope, didn't put a report date down. Now, I'm going to order that the defendant report to this courtroom on December the 29th, which is a Monday, at 11 a.m. He'll be given written instructions on what he needs to do so there can't be any misunderstandings. It is incredibly important that you show up when you are supposed to for this, because if you don't, then a warrant will be issued for your arrest. Instead of doing 10 days on each of the OVI charges, you could end up serving the entire balance for a total of 1 year in jail. And to add insult to injury, the court could find you in contempt for failing to report and add 30 days onto each case, and thereby turning your 23 days of mandatory jail time into 1 year and 2 months of jail. So you need to make sure you have all your arrangements in place well before the day you report so that you can be here. And if I tell you to be here at 11, if I were you, I'd be here at 10:30. Now, Mr. Kodka, the court considers this behavior to be terribly concerning. We don't handle murder cases or rapes or robberies, but people are killed on a daily basis in our country by impaired drivers. I pray that you'll take your treatment and programming seriously, because it's nothing short of a miracle that nobody's been hurt in any of your cases before. And if you continue to drive while you're impaired, the odds are good that we will have a tragedy. So, it's time to make sure that we really deal with why you're sitting here today. Do you have any questions, sir? Anything further, Mr. Brigden? Anything else, Mr. King? Very well. You're going to go with the bailiff, and he's going to go ahead and the interpreter will go with you and continue to assist. Now we're ready for Donnie Dowdy. Donnie Dowdy. Is this the wildlife thing?
This is the one that I wanted to show, and my beautiful spreadsheet that tells me exactly where
This
to
is
go.
25 CRB 788, State v. Donnie Dowdy. That's
Told
you.
me that I needed to go to. Hold on, I'm going to tell you that I needed to go to 33 minutes and 28 seconds. We are at 39 minutes and 44 seconds. So my spreadsheet's not working. And I was going to show you the revocation, but that is at the wrong time. The timestamp's wrong, so I don't know where it is. That's why I stopped Bleckley. And that stinks, but I'm going to fix it, and then I'm going to show you the revocation tomorrow.
Sir.
Yes, sir.
The record should reflect the defendants present in the courtroom today with counsel, Mr. Brigden. We have Mr. King here on behalf of the state of Ohio, and this matter comes on for further hearing, having been scheduled for a change of plea. The defendant is charged with spotlighting deer while hunting, a misdemeanor of the third degree, and in fact, all 4 charges the defendant's apparently going to change his plea are third degree misdemeanors. There's 3 counts of state ownership, title of wild animal. Third-degree misdemeanors are punished by up to 60 days in the county jail, up to a $500 fine, and the defendant would be subject to a suspension of his hunting privileges in the state of Ohio. And that could be a period up to 3 years. And I can't remember, I don't believe, oh yeah, and there is a possibility of an order of restitution as well. Do you understand?
Yes, sir.
Okay. And is it true that you're going to be changing your pleas from not guilty to guilty?
Yes, sir.
And are you aware that you're not required to do that?
Yes, sir.
Do you realize that as you sit before me, I have to presume that you're not guilty of the offense? And I don't think I said it, but the defendant's here with his counsel, Mr. Brigden, and Mr. King is here on behalf of the state. Do you understand that you're presumed to be not guilty? The state has the burden of proof here.
I'm going off camera for a minute just so that I can freely swear loudly at my whole system, because that's the only way I'm going to be able to fix it.
Yes, sir.
And did you know that that burden is proof beyond a reasonable doubt?
Yes, sir.
Are you aware that you have a right to a trial with a judge or a jury?
Yes, sir.
And did you know that at the trial you could, number 1, cross-examine your accusers, number 2, subpoena your own witnesses to compel their attendance, and finally, number 3, you would have the right not to testify, and it wouldn't be held against you if you didn't. Understand?
Yes, sir.
If you plead guilty, however, you admit to committing these offenses. It means the state no longer has to prove anything in order for me to find you guilty. It means you're surrendering your presumption of innocence. And most importantly, it means you're going to be waiving the rights we've discussed, including your right to a trial. Did you realize that?
Yes, sir.
And if I accept your pleas and enter convictions, I'm going to impose sentence upon you today. Did you have any questions about the possible penalties?
No, sir.
Have you been threatened in any way or promised anything to get you to do what you're doing here today?
No, sir.
Are you under the influence of anything right now?
No, sir.
Are you satisfied with Mr. Brigden's advice and representation?
Very much.
And are you a citizen of the United States of America?
Yes, sir.
All right, then the court finds that the pleas and waivers have been knowingly, intelligently, and voluntarily made. The court will accept the same and enter convictions on all 4 charges. Mr. Brigden.
Thank you, Your Honor. With regard to this, we had discussed the $500 fine, the loss of the license for 3 years, and the surrendering of the weapon. Mr. Downey has brought the weapon and has been surrendered. I will note that he's taken this matter seriously. In the beginning of this, which this case, originated a little over a year ago, Mr. Dowdy's recitation of the facts are that the animal was actually killed in West Virginia and brought up here. He self-reported to West Virginia, lost his license for a year there, and paid numerous fines there as a result of it. It is, I know the state contends that it was shot here. It is a tribal fact that Mr. Dowdy wants to conclude this matter, so he is pleading guilty to those elements of the state title ownership. But ultimately, there wasn't a tag on it. It was here in Ohio. I would argue, however, Your Honor, though, that the 3 state title or ownership would merge because it's the same animals. So I believe one was out of season, the other was no tag, and we actually just scheduled the third one.
It looks like count 2 is hunting from a motor vehicle. Count 3 is hunting with a rifle during presumably crossbow season.
can't hunt with a rifle,
Oh.
not that 270.
Gotcha. And then finally, the last one is failure to check the game. So they're actually all different aspects of requirements for hunting. But, I mean, go ahead and make your argument.
Yeah, I'm arguing those are all still the same animus. I mean, I know you can put it into the test and whether or not one can withstand on its own, you know. I'm arguing just for the sake of preservation of the record that there would be a merger at least from the out of season and the hunting with a gun, or the gun one. It's
Sure.
kind of the same thing. At any rate, he took this matter seriously. He hired private counsel. He's come up here. And again, as I said, I think self-reporting in West Virginia shows that he demonstrated remorse for his actions. So we'd ask the court to follow that pre-trial negotiation.
All right, thank you. Mr. Dowdy, you have a right to address the court before I make any decisions regarding your sentence, although you're not required to. Is there anything you'd like to say, sir?
No, sir.
And Mr. King, anything further from the state here?
Yes, Your Honor. Not to belabor it, but we don't believe that deer was shot in West Virginia at all. Another individual who's been charged in multiple counties, Todd Brown, would testify he was absolutely with the defendant. The deer was in fact shot from a gun, utilizing a spotlight after hours with a high-powered rifle, and that rifle was a .270 caliber, which is illegal to use in the state of Ohio. It's not a straight-walled cartridge, and that he left this state without checking that animal. The animal, I think, was rotten by the time it got back. Normally, I would ask for a forfeiture of the antlers. It's illegal for him to possess them. On the other hand, it's my understanding that West Virginia wildlife officers have seized it. Nevertheless, these are serious charges. You don't do that. We are sticking with our request for a 3-year loss of hunting license. Are asking for restitution for $500. We don't have the buck, so the Ohio Administrative Code sets for an antler deer the minimum restitution value, which is $500. And finally, my notes back on September pretrial indicate possibly a weekend in jail or forfeit the rifle. I will verify that the rifle has been forfeited, is currently in possession of a wildlife officer. I meant to get to, but today has not gone well. I will get the court an entry regarding the forfeiture of that .270 Savage rifle, as well as the restitution for the $500 for the antler deer. Thank you.
Which count is the state proposing to order this the license, the privileges suspension, as well as the restitution and
I don't
the
think it
forfeiture?
really matters. Do you have a
It would
preference?
be one of the taking charges, so it would be either the rifle or the jacklighting.
Okay, they're probably the first or the second, either the spotlighting or jacklighting, or shooting the deer with the high-powered rifle.
Okay, thank you.
I suppose I should also, for what it's worth, put in my 2 cents. Hunting violations are strict liability offenses. That being said, these do not merge. Separate acts are required for the commission of each and every one of them.
All right, the record will so reflect. Is the restitution to be paid to ODNR itself or to the state of Ohio?
ODNR itself, otherwise, state of Ohio will keep it.
Well, we do need one more Loge box in the new Cleveland Brown Stadium. Okay, it's going to be the sense of the court as follows, and incidentally, I concur with the Assistant Law Director's recitation of what was discussed at the pretrial conference back on September the 9th. On count one, spotlighting deer, it's going to be a $200 fine. Cost will be assessed. The defendant's hunting privileges in Ohio will be suspended for a period of 3 years. On count two, it's going to be a $200 fine. The court will order that the rifle that was used to commit that offense be forfeited to the state, and I put ODNR in parentheses. And then finally, on that count, the court will order the order of restitution of $500 to the ODNR. On the two remaining charges, will be a $200 fine on each. You'll actually get time to pay if you need it, Mr. Dowdy. If you can pay it off sooner, then that's entirely up to you. But, I will say this. But the first line of my notes from the pretrial conference says, "State wants head on a platter." ODNR took this one very, very seriously. They were very, very upset about the behaviors here. You're an experienced hunter. You know what you need to do and what you can't do, and unfortunately, you're going to suffer some consequences here. But after 3 years, you're going to be able to come back and hunt if you like. Just make sure you follow the rules. Do you have any questions?
I got a few questions. I do have a few questions. So let me get this straight. The DUI guy, that's fine. That's, let's just, give him a light sentence. But the ODNR wanted this guy's head on a platter because of what he did. Kelly, thank you so much. Thank you, thank you, thank you. So he shot a deer, but the DUI guy, which was not his first DUI, that's a lighter sentence? Is that what we just watched? I know, back when we lived with kings, poaching was, death sentence. But DUIs should be harsher. I just feel.
Anything further, Mr. Brigden?
No, Your Honor.
Anything else, Mr. King?
No, sir.
All right, very well. And I will entertain those proposed motions from the state regarding restitution and forfeiture. Okay, and finally, is Mr. Short prepared to go forward today?
Yeah, he's got here from Kentucky. He was texting me as we were finishing Mr. I could go sign up.
Yeah, let's take a brief recess while the paperwork's being done on the short matter, and you guys can draw straws for who gets to be Bobby on this one. Yes, sir.
Jackson, I hate to do this to you.
All rise.
Go ahead and take yourself the record if you would, please.
But I'm supposed to be.
I freely cuss about everything.
Okay,
Damn it.
we're on the record now on the Jordan Short case, 25 TRC 07731. That's you, sir?
Yes, sir.
The record should reflect the defendants in the courtroom with his counsel, Mr. Brigden. Mr. Savage is here on behalf of the state of Ohio, substituting for Ms. Yeager. We're here for the purpose of a change of plea. Defendant's charged with speeding, operating a vehicle while impaired, operating a vehicle with a prohibited concentration of alcohol, and a seatbelt violation. My understanding, Mr. Brigden, is your client's going to be changing his pleas from not guilty to guilty on all charges?
Yes, Your Honor.
All right. And he's charged with two different theories of OVI. Obviously, the court's going to enter one conviction and impose one sentence. The state gets to pick which one that would be, Mr. Savage?
The per se, Your Honor.
Very well. So is it true, Mr. Short, that you are going to be changing your pleas?
Yes, sir.
And do you realize that you're not required to do that, nor can anybody force you to do so?
Yes, sir.
Did you know that you have the right to maintain your presumption of innocence and to hold the state to its burden of proof beyond a reasonable doubt?
Yes, sir.
You have a right to a trial that could be with a judge or a jury. Did you know that?
Yes, sir.
And are you aware that at the trial you would have the right to, number one, cross-examine your accusers, number two, subpoena your own witnesses so as to compel their attendance at the trial, and number three, you could elect not to testify, couldn't be held against you in any way. Do you understand that?
Yes, sir.
If you plead guilty, you admit to committing these offenses, which means no longer presumed innocent, state has no longer any burden to prove anything for me to find you guilty, and you'll waive the rights that we've discussed, including, most importantly, your right to a trial. Do you realize that?
Yes, sir.
Now, if I accept your pleas and enter convictions, I am going to impose sentence upon you today. So the speeding violation, minor misdemeanor, $150 fine maximum. Understand?
Yes, sir.
Seatbelt violation, $30 fine maximum. Any questions there?
No, sir.
And the OVI, and the penalties for you would have been the same regardless of which one the state picked, are up to 180 days jail, up to a 3-year license suspension, and a fine of up to $1,075. Any questions about that?
No, sir.
At a minimum, the court's required to fine you $565, suspend your license for at least 1 year, and sentence you to serve 3 consecutive days in jail, or in the alternative, that you successfully complete a 3-day driver intervention program. Do you understand that?
Yes, sir.
Now, have you been subjected to any threats or promises in order to get you to do what you're doing here today?
No, sir.
Are you under the influence of anything right now?
No, sir.
Are you a citizen of the United States of America?
Yes, sir.
And are you satisfied with Mr. Brigden's advice and representation?
Yes, sir.
And I find that your pleas and waivers have been knowingly, intelligently, and voluntarily made. I will accept the same and enter a conviction upon the record. Mr. Brigden, anything you care to say on behalf of your client?
Yes, Your Honor.
Yes,
We
yes,
tried
we
this on
can.
October 14th, pre-trial, we had discussed.
I
driver
do have a
intervention
members
program,
only stream I want to play.
terminate After.
There's no
completion of that
camera,
and fines. I will
but there's
note that,
audio.
Mr. Short lives in Kentucky, Lexington, Kentucky, about
I'm
3.5
looking at my
hours
work
away.
schedule to
He
see
lives
when I
there with
can do
a
it.
girlfriend, he's just 21 years old. He's been doing door-to-door sales for internet packages for approximately 3 years now and has no prior criminal history.
All right, thank you. Mr. Shore, you have a right to make a statement if you like before I make any decisions here, but you're not required to. Is there anything you want to say?
No, sir.
And Mr. Savage, anything further on behalf of the state?
No, Your Honor.
Okay, very well. Obviously, Mr. Short, you made a pretty major mistake back on August the 21st of this year. Youth can only get you so far as being excused from certain behaviors. I guess this is my nice way of saying you know better. You should have made better choices. Thankfully, you weren't injured, nor did you injure or kill anybody else. But the chances of that happening if you continue to drive while under the influence continue to skyrocket. So, you know, I guarantee you that every single person who sits where you're sitting and they're here for a second or a third OVI thought to themselves when they were sitting there for their first one that they'd never be back here again. And I'm sure you're thinking that yourself right now. You're the only one who can control that, so it's important that this is the only time you find yourself here. Understand?
Absolutely.
Very well. Speeding violation is off the court's traffic schedule, so extrapolating from that, that's $114. The seatbelt violation is going to be $30, and on the OVI, the court will impose a 30-day jail term, suspend all but 3 days, and put the defendant on probation for a year. As a term and condition of probation, he'll be required to successfully complete an Ohio-based approved driver intervention program, so looks like you're going to be spending some time just across the river there in Cincinnati to get that taken care of. While there, you'll participate in a drug and alcohol screening. If they recommend follow-up counseling, you'll be required to do that until released in writing. If not, they won't. Then you won't. No drinking to excess, no use of illegal drugs, and no abuse of prescription meds. You need to maintain suitable employment unless you decide you want to go back to school or get a further vocational training, and otherwise follow any other rules the probation department sets. I'll impose the minimum fine of $565 in order that you pay costs. It'll be a 1-year license suspension, which we'll talk about here in a moment, and in fact we'll talk about now. By my calculations, the defendant's ALS expired approximately 6 days ago. I'm assuming that you have not. Did you receive a letter from the Ohio Bureau of Motor Vehicles telling you about your suspension and how to pay a reinstatement fee?
No.
Okay, so he hasn't reinstated.
He's a Kentucky driver.
Well, it would still been subject to the interstate compact, so.
Are you saying my license is suspended?
Your license was suspended the moment you registered a .092 breath test. Now, the way that works is there's a thing called the interstate compact in which most states, I think there's maybe 2 or 3 that aren't members of this, basically they've agreed to rat out each other's citizens. So Ohio says, hey, Kentucky, if you get a guy over here, something happens, he gets some conviction, or if the court takes certain action, we're going to notify you. And we'd appreciate it if somebody from Ohio gets in trouble in your jurisdiction that you let us know. So what would have happened was A, you were placed under suspension the date of your citation. Number 2, Kentucky would have been notified. The Bureau of Motor Vehicles in Kentucky would have been notified. I don't know what reciprocal action they would take. That's something you're going to have to look into. And then finally, the 90-day period of suspension would have expired on November the 19th. So technically, right now,
murder.
you're not under a suspension, but you are under a requirement to pay a reinstatement fee. If you were to be pulled over at this juncture, like this very second, you could be charged with failure to reinstate a license, and under Ohio law, for you, that would be an unclassified, carrying no jail time, but the possibility of a fine and license suspension. So the long and the short of it is, Kentucky will know about this. What action they take, I don't know. Okay? All right.
Okay, yeah, just to be clear, so my license is suspended currently in Ohio, but not in Kentucky?
I have no idea what your license status is in Kentucky, and you're no longer under an active suspension in Ohio. At this point, you're subject to a requirement to pay a reinstatement fee in order for Ohio to recognize your privilege to drive in our state.
Okay. Yes,
Okay? All right, very well. So I think what I'll do, just to make sure that we don't have any problems, I'm going to give him the credit for the 90 days of the ALS, but I'm going to set the suspension out about 3 weeks. He can submit an application for limited driving privileges. Again, I don't know how that works, whether Kentucky would honor the order of an Ohio court, but you have the right in an Ohio court to ask for limited driving privileges, which will apply in Ohio. You'll need to talk to Kentucky to find out, hey, if I get limited driving privileges after a mandatory license suspension in a different state, A, am I going to be suspended? And B, if I
Monday.
am, do those privileges extend to my home state?
Oops, that's not what I wanted to press.
All right, so it gets a little complicated when you live in one state and you're convicted in another, but unfortunately,
I created the live stream. It's on Monday at 7:00 p.m.
that's just an extra consequence that you're facing and dealing with right now. So, yeah. So let's go ahead and set that out about 3 weeks. That means it'll be about the 16th of December. And you are eligible to apply for limited privileges. My bailiff can provide you with the form if necessary, and then you can take that home, get it filled out, and mail it back into the clerk's office. So you'll get time to pay on your fines and your costs. They'll give you the details in the clerk's office. Do you have any other questions today?
No, sir.
Anything further, Mr. Brigden?
No, Your Honor.
Anything else, Mr. Savage?
No, Your Honor.
Very well. This court stands adjourned.
All rise.
All right, guys, we made it. We made it to the end of that probate case. And then we did a little deer hunting, a little DUI. I'm going to fix my stuff. I have ideas on how to fix it. Soon it's going to be so good. All right. What is today? Thursday? So it's just a regular day. Go, guys. Go make today a Saturday instead of a Thursday. Do something to make it a Saturday. You can. You can do that. I hope you guys have a great day. Thank you so much for coming out. I'm going to set up OJ and then I'll see you all later. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like a guaranteed good time.